Hello, thank you for joining us today for the first in a series of webinars that the Education Rights Institute will be presenting on civil rights protections from race, color, and national origin discrimination. Before we begin, we'd love to know where you're from and working if you'd like to share that with us. So please use the chat to tell us what school district, city, and state you're joining us from today. And if you're working in a private school or a charter school that isn't part of a district, we would welcome you sharing that information too. Wherever you're from, we are very excited you've taken time out of your busy day to join us. My name is Kimberly Robinson, and I'm the founder and director of the Education Rights Institute at the University of Virginia School of Law, as well as a professor here. In a former life, I represented school districts and served our nation as a civil rights attorney for the U.S. Department of Education. I know that all of you who are teaching in and leading our schools serve as the very foundation of our education system. And I want to empower each of you to understand and implement civil rights protections in the classroom, because that is how we will all work together to turn equal educational opportunity from rhetoric to reality. I'm excited to share that we have some opportunities to win gift cards. I don't know about you, but I love a prize. We want to provide a prize to some of the teachers who are joining our efforts to expand their understanding of civil rights protections. And so there are 3 chances to win. First, at the end of today's webinar, we will randomly select 3 educators to win $100 gift cards. Second, we really want to know how this webinar made a difference in your classroom and schools. So on Wednesday, November 12th, we'll send a survey that will ask you about how you're implementing what you learned. That gives you 2 weeks to think about what you've learned and put it into practice, and then share it with us. We'll select 3 educators who complete the survey to win a $50 gift card. Mark your calendar now for November 12th so that you'll look out for that survey. You won't want to miss it. I know you all, like us, have very busy inboxes, so make sure you mark your calendar. And then finally, we want your help spreading the word about implementing civil rights protections in the classroom and all that you learned in this webinar. We encourage you to share one thing that you learned on either LinkedIn or Instagram, and to tag the Education Rights Institute in your post by Wednesday, October 29th at midnight. We will message 3 of you to earn a $25 gift card for helping us spread the word. Now I'm just going to go over some quick logistics. This presentation is being recorded, so educators who are not able to join us today can watch it at a later time. They also are eligible to win the gift cards for posting on social media and completing the survey. The opinions expressed in this webinar are solely those of the Education Rights Institute. If you have questions during the presentation, please use Zoom's Q&A feature to submit them. We have moderators keeping an eye on the Q&A, but questions that are posted in the chat could get overlooked. You'll find the Q&A button at the bottom of your webinar screen. We'll do our best to answer as many of those questions as we can at the end of our session. Today, I'm joined by Dr. Sarah Beach and Dr. Helen Min, as well as Tegan Delane and Bridget Joyce, 2 attorneys with the Institute. They will each introduce themselves. So thanks again for being here, and let's get started.
Hi, I'm Dr. Sarah Beach. I'm the Director of Research here at the Education Rights Institute. I began my career by teaching for 6 years in Virginia public schools before earning my PhD at UVA's School of Education and Human Development. Today, we're going to introduce the Education Rights Institute, explain federal civil rights protections against race, color, and national origin discrimination, and provide some examples of how those operate in classrooms and schools, and then we'll finish up with Q&A. I want to start by sharing a little bit about who we are. The Education Rights Institute, or ERI, is a multidisciplinary team of legal scholars and social scientists that advance equal educational opportunity. We engage policymakers, K-12 educators, and families to expand the opportunity for all students in the United States to access a high-quality public education that empowers them to be college and career ready and engaged civic participants. When we talk about students who are college and career ready, we mean students that can access their introductory college courses or their first step in their career without needing additional remediation or support. When it comes to engaged civic participation, we don't just mean voting, although that, of course, is important. We also mean things like knowing how to have respectful, productive conversations in the classroom with people who see things differently than you, or being able to think critically about the media that you're consuming. As former classroom teachers, Helen, who you'll meet in a second, and I understand how important it is for teachers to have easy to use resources that present critical information in ways that are clear, actionable, and most importantly, effective. Helen?
Thanks, Sarah. Hi, everyone. I'm Dr. Helen Min. I'm a fellow at the Education Rights Institute and research faculty member at the UVA School of Law. Before I joined this team, I spent 6 years teaching, most of which was for Baltimore City Public Schools, and I earned my PhD in education at UVA. I know this is a really busy time of the year, so we are particularly grateful for your time this afternoon. To help you provide a high quality public education and advance equal educational opportunity, we put together a variety of easy to use resources like our 2-minute videos and one-page guides that you can quickly access whenever you need them. If you want to explore a topic in more detail, we also have an in-depth report to help you tackle some key challenges that are facing today's classrooms. You can find all of these materials on our website, which we are now linking in the chat. Please share our resources with other educators, principals, district administrators, and school board leaders that could benefit from this information. We'll start with a quick and fun quiz to see what you already know about the Title VI of the Civil Rights Act. Go ahead and select your answer using the poll on your screen. I hope you've submitted your answers. The correct answer here is D. Title VI protects students from discrimination based on race, color, or national origin. It's important to note that it does not cover things like sex, disability, income level, or ethnicity. Here's another question. Take a moment to choose your answer to this poll. I hope you've submitted your answer. The correct answer here is B. Looks like most people put that answer. Title VI applies to any school or education program that receives federal funding. That includes state education agencies, school districts, all public schools, even public charter schools, and any private schools that get federal funds. Here's our final question. Please choose an answer by responding to the poll. The correct answer here is C. Title VI protects students from discrimination based on race, color, or national origin in all school district programming and activities, not just the ones that directly receive federal funding. So if a district gets any federal funds, Title VI applies across the board.
So, as is clear from these questions that we've asked, the primary law that we're going to be speaking about today is Title VI of the Civil Rights Act of 1964. You may have noticed Title VI is in the news a lot these days, and we're looking forward to sharing with you how Title VI protects students in schools so that you can be implementing these protections in your classrooms, schools, and districts. For decades, federal dollars had been used to support schools and programs that discriminated based on race, color, or national origin. Congress passed the Civil Rights Act of 1964 to stop the use of federal funds to finance discrimination.
Hello, everyone. My name is Tegan Delane, and I am a director of programming here at ERI. Prior to joining ERI, I served as Associate General Counsel for a public school charter network operating in the Northeast and New England. The straightforward explanation of Title VI is that it is a federal law that prohibits discrimination based on race, color, or national origin by any program or activity receiving federal financial assistance. That includes state education agencies, all public school districts and schools, including public charter schools, and any private or parochial school that receives federal funding. And I was thrilled to see that so many of you got this question right on our quiz.
Hello, I'm Bridget Joyce. I'm also a director of programming at ERI. Before joining ERI, I spent more than a decade developing guidance about Title VI at the U.S. Department of Education's Office for Civil Rights. Title VI's prohibition on discrimination based on race, color, or national origin is broad. For example, Title VI extends to all of a district's programming, not just individual programs and activities that directly receive federal funds. That includes all of the programs listed on this slide and whatever other programs or activities a district operates. Title VI applies in the school building and also beyond, in settings like the school bus and school field trips. Title VI applies to the conduct of administrators, teachers, staff, and anyone who carries out school functions. So that includes, for example, bus drivers, recess monitors, and school resource officers.
Creative resources to empower each of you to implement Title VI in your classrooms and schools by providing resources we have created to help educators, students, and families understand and implement civil rights protections under Title VI. These are all available on our website, and we hope that after our webinar, you'll take some time to explore them. Our Title VI primer, which you see here on the screen, the cover of, is a report that provides an overview of the obligations of school districts under Title VI. This report also explains the process that the U.S. Department of Education's Office for Civil Rights has historically used to enforce Title VI. And we have two short videos that we think you will find informative. Both are under 3 minutes. Our Title VI video on preventing and remedying racial discrimination in schools explains school districts' obligations under Title VI. And our Title VI video on disparate treatment and disparate impact explains two different legal analyses under Title VI. We explain both of these types of discrimination in this webinar and how to identify them. Do you want a quick summary of the law that we're reviewing today? We've got you covered. We have two summaries for Title VI. One is designed for educators, and one is for district leaders. Each covers the highlights of our Title VI primer, and each points to pages in the primer in case you want more information. The guide shown on this page is for educators. You can download it with this QR code, the link in the chat, or you can find it on our website at some later point. We would love for these summaries to be in every teacher's lounge and principal's office across our nation. Here's the summary for district leaders. Those include central office staff and school board members. It's focused on district-wide policies and how to change them to implement Title VI. It would be helpful for anyone who how to advocate on behalf of students.
Both the U.S. Department of Education's Office for Civil Rights, or OCR, and the U.S. Department of Justice, or DOJ, enforce Title VI in the education context. OCR is required to process every complaint that it receives. OCR processes far more Title VI complaints than DOJ. And after a long day, it's time for a fun, no-pressure Title VI pop quiz. How many race and national origin discrimination complaints did OCR receive in fiscal year 2024?
The correct answer here is B, 4,307. In fiscal year 2024, the Office for Civil Rights received nearly 23,000 complaints, and over 4,300 of those involved concerns about race or national origin discrimination. Unfortunately, OCR has been understaffed for quite some time, and that challenge has only grown worse due to major staffing cuts this year. Even with fewer staff, OCR still actively works to review and process complaints, though it might take a little more time than usual.
Great, so let's take a look at what Title VI prohibits. There are a number of different types of discrimination that are prohibited by Title VI. Disparate treatment, disparate impact, retaliation, and hostile environment. In the next group of slides, we're going to cover disparate treatment and disparate impact, and then we're also going to talk about retaliation. We are hosting a full webinar on racial harassment and hostile environment in schools this winter. Under Title VI, disparate treatment refers to intentional discrimination based on race, color, or national origin. In case you're wondering, does intentional discrimination still happen today? Unfortunately, yes, it does, which is why it is important to understand both that the law prohibits it and how to spot it. A complaint for intentional discrimination can be filed in federal court or with the Office for Civil Rights or the Department of Justice. Courts and federal agencies can consider both direct and indirect evidence to determine whether a school district engaged in intentional discrimination in violation of Title VI. Sometimes intentional discrimination is quite easy to spot. That's what we call direct evidence. For example, if a school policy clearly says that a student of a certain race can't participate in a particular program, that would be direct evidence. Or a school employee says they acted based on race or national origin, that also is direct evidence. But in many instances, intentional discrimination isn't that clear. That's when indirect or circumstantial evidence should be considered. Indirect evidence can include actions like statements by school or district employees, changing how they implement a practice or procedure and statistical patterns. These and similar actions can provide clues that can still point to discrimination.
So I'm going to let you in on a little secret. Lawyers love a three-part test. After 3 years of law school, I saw myself applying three-part tests to decisions about produce in the grocery store and sometimes my dinner order on date night with my husband. Most recently, I applied it when deciding whether or not to go to my mother-in-law's house for dessert after Thanksgiving dinner. So, not surprisingly, I'm about to share with you a three-part test that is used to determine if intentional discrimination has occurred. Consider these three questions. First, you want to ask, did a school treat a student or students in an adverse way while it treated a similarly situated student or students of a different race, color, or national origin more favorably? An example of treating a student in an adverse way is limiting or denying an educational opportunity, like participation in a school program or exclusionary discipline. If the school did not treat a student in an adverse way, while it treated similarly situated students of a different race, color, or national origin more favorably, then there's no Title VI concern under this test. If the school did treat the student in an adverse way, then you want to move on to step 2. Under step 2, consider whether the school can provide a legitimate and non-discriminatory reason for the different treatment. For example, can the school cite an educational necessity for treating these students differently? If not, that could be considered a Title VI violation. If yes, then proceed to step 3. So in step 3, you want to consider whether the reason provided is the real reason. So if the non-discriminatory reason that was offered is not the real reason, the district likely violated Title VI. You might call it a cover story. My grandmother used to call it spinning a yarn. My mother didn't allow us to say people were lying, so we had to call it fibs. Lawyers call it a pretext, but whatever you call it, the non-discriminatory reason offered by the school district is not the actual discriminatory reason. However, if the non-discriminatory reason is the real reason, also known as the truth, there would be no Title VI violation. OCR frequently uses this framework in Title VI investigations, so it may be helpful for you to familiarize yourself with it.
As you think about how to spot intentional discrimination, you might be wondering what kinds of indirect evidence to look for. It's important to look at the whole picture when considering indirect evidence. One example of indirect evidence could be when normal procedures are not applied consistently. So think about a principal who might bend discipline rules for students of one race, but enforce those rules strictly for students of other races. Another example is to look at the events leading up to a decision. Consider a PTA meeting where people complain about Black students wearing their hair in locks or afros. Soon after, the school district adopts a dress code banning distracting hairstyles. Even if the policy doesn't mention race, the timing and the context matter and can help reveal that discrimination could be at play.
Let's make sure we all understand how this legal standard works by walking through an example. On your screen, you'll see a fact pattern about a complaint. A Black student and an Asian student at an urban middle school were involved in the same physical fight, but they were treated differently afterwards. Take a moment to read through the scenario. You should see a pop-up on your screen asking, do these facts raise any concerns under Title VI? What do you think? We'd also love to hear your thoughts in the chat about what other questions you would want to ask to better understand the situation.
All right, I see that the majority of you answered that these facts raised concerns under Title VI. In this scenario, the principal treated the two students in the same fight quite differently. The Black student received a harsher punishment than the Asian student. To determine if disparate treatment occurred, we first consider whether these two students are similarly situated. The students were involved in the same fight, and neither has a disciplinary history or had a weapon. Remember, students don't have to be identical, but they do need to be comparable in order to be considered similarly situated. If the students are similarly situated and the school still treated them differently, we ask, did the school have a legitimate non-discriminatory reason for disciplining the Black student more harshly than the Asian student? For example, the school might say one student started the fight, had a weapon, threatened a school official who stepped in. If the school can't offer a legitimate non-discriminatory reason, that difference in treatment could point to a Title VI violation. If the school does provide a reason, our final step to ask, is that the real reason? If the evidence shows that the stated reason is not the real reason and instead is merely trying to cover up discrimination, that too could be the basis for a Title VI violation. Whether it's discipline, grading, access to gifted and talent programs, or other benefits in a school, this type of discrimination persists in our school today. When you learn how to spot and prevent disparate treatment, you become part of the team fighting to end discrimination so that all students can thrive.
Now we're going to pivot to discuss a different type of discrimination that is focused on discriminatory effects rather than intent. This is called disparate impact. In this slide, you can read the regulatory language that was adopted to prohibit disparate impact discrimination. It's, I think, noteworthy that this language was adopted in 1964 before the U.S. Department of Education was even established. We call this type of discrimination disparate impact because it does not require that discrimination be intentional. Disparate impact liability has historically been an important tool in combating discrimination based on race, color, or national origin. This is in part because intentional discrimination can be very hard to prove and does not always address systemic discrimination. One of the ways that educators, principals, district administrators, and school board leaders can bring equal educational opportunity to life is to review your policies and practices to determine if they impose an unlawful disparate impact. If they do, consider adopting alternative policies and practices that empower all students to thrive. All federal agencies have adopted Title VI regulations that prohibit discriminatory effects based on race, color, or national origin. We do not expect to see very much use of disparate impact liability under Title VI during the current administration due to a 2025 executive order, which we will explain shortly.
We mentioned earlier that lawyers love a three-part test. Here's another one. This test is used to decide when a practice or a policy that looks like it applies to everyone equally actually results in an unlawful disparate impact that violates Title VI. The first step is to look at whether a policy or practice that looks fair on its face actually has a negative impact that falls more heavily on a particular group based on race, color, or national origin. For example, consider a policy that students who are late receive in-school suspension at a school where Latino students are more likely to be late because most Latino students take an unreliable bus to school. But remember, a policy that negatively affects a particular group based on race, color, or national origin does not by itself violate Title VI. That just means that we move on to step 2. Step 2 asks whether there is a good reason for the policy or practice. In this example, the school might say that the reason is that they want to encourage students to be on time so that they don't miss instruction. If the school provides a good reason, we move on to step 3. The last step is to consider whether a different policy could have reached the same goal without having such a negative effect on a group of students. In this example, the school could consider creating an exception to its policy for students who are late because of the bus. And they could also work with the district to adjust pickup times to get students to school on time. We wanted to explain disparate impact because it has been an important tool in addressing discrimination and identifying and revising policies and practices that have a negative disparate impact on a particular group of students will always be an important tool for educators who want to ensure equal access to education for all kids. We also want to acknowledge some important limits to be aware of. First, a person cannot sue under Title VI disparate impact theory in federal court. So that means that only a federal agency, like the U.S. Department of Education, can enforce the Title VI disparate impact prohibition. But this year, the current administration issued an executive order that introduced a major change in this area. Tegan will tell you more.
This executive order, issued by the Trump administration in April 2025, tells the Attorney General to repeal or change Title VI regulations that prohibit disparate impact discrimination. The executive order also directs federal agencies to stop enforcing disparate impact liability as much as possible. In September 2025, the U.S. Department of Education announced that it intends to remove the regulation under Title VI of the 1964 Civil Rights Act that prohibits disparate impact discrimination. Therefore, we don't expect to see federal enforcement of the prohibition of disparate impact discrimination under Title VI during the current administration. If the disparate impact prohibition is successfully revoked, we may not see enforcement of disparate impact liability by the Office for Civil Rights moving forward. It is important to note that numerous state laws prohibit disparate impact discrimination, so you should check the law in your state.
You might be wondering what other types of discrimination Title VI prohibits. Title VI also protects all students, including Arab, Hindu, Jewish, Muslim, and Sikh students, from discrimination based on actual or perceived shared ancestry or ethnic characteristics. For example, harassment of an Arab Muslim student from wearing a hijab could contribute to a hostile environment that implicates Title VI. The presence of swastika graffiti could also contribute to a hostile environment that would raise Title VI concerns, depending upon the adequacy of the school's response. Title VI does not protect students from discrimination based on religion. There are other federal laws that protect students from discrimination based on religion, but those protections are outside the scope of this webinar. As we noted earlier, this winter, we'll be hosting a webinar that explains how Title VI applies to harassment based on race, color, or national origin.
Here's another type of discrimination that Title VI prohibits. Title VI forbids schools and districts from retaliating against anyone because they told the school about a Title VI concern, filed a complaint, or helped in any way in a Title VI investigation. Retaliation can look like a school threatening the person who complained, pressuring someone who helped in an investigation, or taking something away from someone because they raised a Title VI concern. The purpose of this rule, as you might imagine, is to protect people who raise concerns or help with the Title VI investigation. Schools are not allowed to punish people for speaking up about their Title VI concerns.
Now we will turn to how OCR processes complaints, including complaints about race, color, or national origin discrimination. As you can see from this slide, the way that OCR processes complaints is complicated. For today, we want to focus on a few key takeaways. When OCR decides to open a complaint, they tell both parties and explain what they will be investigating. In the investigation, OCR is an objective fact finder. In other words, OCR cannot take the side of either party. Their job is to find out what happened and decide whether there is enough evidence to say that the school violated the law. OCR and the school can enter a voluntary resolution agreement at any time. If OCR finds a violation, Title VI requires OCR to try to resolve the violation through voluntary means. That means working with the school to try to fix the problem. Title VI also requires OCR to take other steps before it takes federal funding from the district. In the past, OCR almost never took federal funding away from districts due to a Title VI violation. But recent reports suggest that OCR may not be following all of the same steps as it has in the past. The Department of Education has also signaled that it may be more common moving forward for OCR to take federal funding from districts. Now we are turning to some common questions that have been coming up across the country about what Title VI does and does not say. You may remember that OCR issued a Dear Colleague letter in February that caused broad confusion about how Title VI applies to certain programming in schools. Ed also sent all state-level officials overseeing K-12 schools a certification requirement in April. We know that there have been many questions about whether these documents change how Title VI applies to schools, so we wanted to address that question first. The answer is no. These documents do not change how Title VI applies in schools. In fact, a federal court vacated both documents in August. That means that the government cannot continue to enforce, implement, or otherwise use these documents. The court found that the documents violated a federal law called the Administrative Procedure Act. The court also noted that OCR's guidance conflicted with OCR's own regulations and existing case law. The court also said that the documents were unconstitutionally vague, in part because they did not clearly define what was not allowed. Portions of the letter also violate the First Amendment by making rules about speech based on its content. We want to note that the Department of Education has appealed the court's decision. That happened on October 15th. The lower court's decision is still in effect today, October 28th. If you watch this webinar at a later date, it will be important to check on the status of this case. Our social media will also provide updates on this and related decisions. Now we want to dive in to what Title VI does say about programming in schools.
Many schools may be ending or considering ending programming that is designed to create a supportive and welcoming learning environment for all students, even though those programs do not violate federal law. Our hope is to clarify the law and answer a few of your common questions about race-related programs and activities and Title VI over the next several minutes. So, does Title VI bar schools from recognizing student groups with race-related themes, such as a Black Student Union or Asian Student Association? Please use the chat to tell us what you think.
Great. Most of you recognize that Title VI does not bar schools from recognizing student groups with race-related themes, as long as they meet three conditions. First, the groups must be open to all students without regard to race, color, or national origin. Second, the groups cannot treat students differently based on race, color, or national origin. And finally, the groups cannot create a hostile environment based on race, color, or national origin for any student.
Let's think about another question. The next question relates to whether Title VI bars students or bars schools from recognizing or supporting celebrations related to race or national origin, such as Chinese New Year or Cinco de Mayo. Tell us in the chat, what do you think?
Wonderful. Most of you answered that Title VI does not bar schools from recognizing or supporting celebrations related to race or national origin, such as Chinese New Year or Cinco de Mayo. These celebrations are permissible as long as they meet the same three conditions just noted. They are open to all students without regard to race, color, or national origin. They do not treat students differently based on race, color, or national origin, and they do not create a hostile environment based on race, color, or national origin for any student.
This next question relates to race and curriculum. Does Title VI bar schools from offering classes that focus on a history or culture of a particular group of people, such as an African American studies class or a class on Chinese language and culture? Let us know what you think in the chat.
Excellent. I think everyone is seeing a pattern here. Most of you recognize that Title VI does not bar schools from offering classes that focus on the history or culture of a particular group of people, as long as they meet these three same conditions. The classes must be open to all students without regard to race, color, or national origin. They cannot treat students differently based on race, color, or national origin, and the classes cannot create a hostile environment based on race, color, or national origin for any student.
I know that we covered a lot of information today, so we want to wrap up by reminding you of the key points we want you to take away and share with others in your schools and districts. Don't forget about our summaries that you can post in your teacher's lounge and in districts and administrative offices. So we discussed how Title VI prohibits schools from discriminating based on race, color, or national origin by any school district, including charter or private schools, that receives federal funding. The first two types of discrimination that we learned about today are disparate treatment and disparate impact. Title VI prohibits intentional discrimination, also known as disparate treatment discrimination, based on race, color, or national origin, which can be shown through direct or indirect evidence. We also discussed the federal regulations that prohibit disparate impact, explain we don't expect to see enforcement in this area during the current administration. We noted also that state law may still prohibit disparate impact discrimination. We encourage everyone to examine their classrooms and schools' policies to see if they result in an unlawful disparate impact. If you uncover a policy or practice that does impose an unlawful disparate impact, the best course of action is to adopt an alternative approach to achieving this educational goal that doesn't involve a discriminatory disparate impact.
We also noted how Title VI bars discrimination based on shared ancestry or ethnic characteristics. Title VI also prohibits retaliation against any individual who raises Title VI concerns, files a complaint, or participates in a Title VI investigation. Finally, as you saw from our answers to common Title VI questions, when creating groups or clubs, celebrating culture, or teaching curriculum, if schools make sure that those programs are open to all students without regard to race, color, or national origin, do not treat students differently based on race, color, or national origin, and do not create a hostile environment based on race, color, or national origin for any student, then those programs are lawful under Title VI.
As we transition now to Q&A, we want to remind you that we have more webinars coming up that you won't want to miss. This winter, we'll be hosting a session on racial harassment and hostile environment in schools. Then in the spring, we'll offer a webinar focused on supporting multilingual learners in schools. We'd love for you to join us for these upcoming sessions and bring a friend, invite a colleague, or share with your school.
We also encourage you to take the time to download our resources about Title VI. We encourage you to share these links with your colleagues and building and district administrators, as well as your school board members.
So as we switch over to the raffles, I just want to offer a thanks to our sponsor, the Education Law Center, and a reminder of the 3 raffles that we are planning to do. For those who may have joined us after my introductory remarks, I want to remind you of those opportunities. First, after the Q&A that we're going to turn to soon, we'll select 3 educators to win $100 gift cards. Second, we want to know how our webinar is making a difference in classrooms and schools. On Wednesday, November 12th, we'll send out a survey that will ask you how you're implementing what you learned in your classroom or school. And we will randomly select 3 educators who complete the survey to win a $50 gift card. So you'll want to mark your calendar now to look out for that survey on November 12th. And finally, we need your help to spread the word about implementing civil rights protections in classrooms and schools. And we want you to share what you learned today. We encourage you to share one thing that you learned on LinkedIn or Instagram and tag the Education Rights Institute in your post by 2 days from now, Wednesday, October 29th at midnight. You may want to put a reminder to post as well, or just when you hop off the webinar, go ahead and post something that you learned. We'll message 3 of you that you've won a $25 gift card for helping us spread the word. So now we will be stopping the recording and we'd love to answer any questions that you have. When we finish with Q&A, we'll select 3 members of the audience to receive $100 gift cards. We look forward to seeing you and a colleague at our next webinar. Thanks so much for joining us.
And while we're answering your questions, we invite you to follow us on social media and sign up for our newsletter. You can use the links in the chat or at the bottom of our website, which is accessible through the QR code on the screen. And you can use our social media to tag us when you share what you learned today so that you can possibly win one of our $25 gift cards. Connecting with us will also help you stay up to date about our future webinars and other resources. If you have questions that we don't get to today, you can always reach us by email using the email address shown on the slide.